Welcome back to another Explainer. Today we're unpacking a really fascinating legal mystery from the Constitutional Court of South Africa. We're looking at case CCT34/95, which centers around a man named Oded Besserglik. Now this case tackles a friction point I think we can all instantly understand. Look, when you lose a legal battle, your natural instinct is to just keep fighting, right? But what happens when the legal system steps in and literally tells you, no, you can't?
Okay, let's dive into this by looking at our central dilemma. Is an automatic appeal a constitutional right? Just put yourself in the applicant's shoes for a second. You take someone to court, you spend a ton of time and money, and boom, the judge rules against you. You're probably going to say, I'm taking this to a higher court. But do you actually have the automatic right to do that? Or can the justice system essentially put a locked door in front of the appellate court and force you to ask for the key? That's the exact problem Mr. Besserglik dragged all the way to the highest court in the land.
To really get his battle, we need to understand the exact legal mechanism at the heart of it all. We're talking about something called leave to appeal. Specifically, this is under Section 24B of the Supreme Court Act. In plain English, it's a precondition. The law says you absolutely need permission or leave from the very same court that just ruled against you before you can move your civil appeal forward. If they say no, well then you've got to go beg the appellate division for that permission. You can't just auto-escalate your case up the ladder. You have to get that initial green light first.
So here's the quick roadmap for our explainer today. We're going to look at 1. Does the right to appeal actually exist? 2. A rare direct access procedure. 3. Section 22 and accessing courts. 4. Section 8 on true equality. And finally, 5. The final judgment.
Section 1. Does the right to appeal exist? This perfectly highlights that initial fundamental friction between a litigant who desperately wants to keep fighting and a legal system that has to set boundaries. Section 2. A rare direct access. Let's look at exactly how this specific civil dispute managed to bypass all the normal routes and land straight at the Constitutional Court.
Besserglik's timeline really paints a picture of a man just desperately trying to keep his case alive against mounting rejections. In August 1994, his original damages claim was dismissed. He tried to appeal, but in May 1995, his application for leave to appeal was flat out refused. Later, that exact same month, he petitioned the appellate division, basically just begging for a postponement so he could get to the Constitutional Court. And they refused him too. Finally, in September 1995, after having doors slammed in his face at literally every turn, he applied for direct access to the Constitutional Court. He was entirely out of options.
Now, what's really interesting here is how the court actually let him in, despite him making some pretty massive procedural errors along the way. He completely missed the proper referral rules in the lower courts, but the Constitutional Court granted him direct access anyway? Why? Well, two big reasons. First, as we saw, he was totally out of legal recourse. If they didn't hear him, nobody would. But second, and this is crucial historical context, the 1993 Constitution was brand new at this time. The court acknowledged that the absolute novelty of the Constitution probably confused him. So they gave him a pass on his blunders because the whole legal system was just in this massive transitional learning phase.
Moving on to Section 3, Section 22, accessing courts. Let's dig into his first specific constitutional challenge.
Okay, so having finally made it through the door, Besserglik had to actually present his arguments. His first big swing relied on Section 22 of the Constitution, which guarantees the right to have a dispute settled by a court of law. And his logic is actually pretty intuitive. He argued that if the Constitution guarantees you access to a court, that right must, by necessary implication, mean you get to take your case all the way to the top. From his perspective, a screening process where you have to ask a judge for permission to appeal is basically a roadblock. He felt his constitutional right to have his dispute fairly determined simply wasn't complete until an appellate court had the final say.
Well, the court vehemently disagreed. In a definitive ruling, Judge O'Regan stated, "A screening procedure which excludes unmeritorious appeals is not a denial of a right of access to a court." The court's counter-reasoning was that this leave to appeal process isn't a barricade at all. It's a vital legal filter. It creates a framework for higher court judges to reassess the case and make an informed decision on whether the appeal actually has any real prospect of success. Because if a case has no merit, filtering it out early saves everyone a ton of time and resources. You still had your access to a court, you just don't get a guaranteed VIP ticket to every court.
Which brings us to Section 4, Section 8, true equality. This is where his second challenge shifts away from access and leans heavily into whether different courts are applying the rules of justice fairly.
Here's the contrast that was driving him crazy.
At the time, if your case was heard in the lower-tier magistrates' courts, you had an automatic right of appeal to a higher court. Boom, no permission needed. But because Besserglik's case happened to be heard in the higher-tier Supreme Court, Section 24B kicked in. That meant he had to formally ask for leave to appeal. The rules were fundamentally different, and it was based entirely on which courtroom you started in. So the applicant's stance was pretty straightforward. He argued that true equality before the law means identical procedures for everyone. If someone in the magistrate's court gets an automatic appeal, why doesn't someone in the Supreme Court get the exact same treatment? He firmly believed this discrepancy violated the Equal Protection Clause guaranteed by Section 8.
And this brilliantly illustrates the court's logic on the matter. They drew on a previous ruling by Judge Madala stating that equal protection of the law does not require identical procedures across different tiers of courts. The key takeaway here is that as long as everyone appealing from a specific court is subject to the exact same procedures, the requirement for equality is met. Everyone in the Supreme Court plays by Supreme Court rules. Everyone in the Magistrates Court plays by Magistrates Court rules. That is true legal equality. So, there was absolutely no unfair discrimination happening here.
Section 5, the final judgment. Let's see how this all wraps up, including a pretty wild procedural twist right at the very end.
Okay, so the court has completely dismantled both the Section 22 and Section 8 arguments. But right before the final ruling, there was this shocking timeline of events regarding Besserglik's own legal team. The court had set very strict directions for filing arguments. The respondents filed theirs right on time, December 4, 1995. Besserglik's team had 1 week until December 11th to reply. Well, they missed the deadline, and days turned into weeks, weeks into months. Finally, on May 13, 1996, a full 5 months late, and literally 1 single day before the final judgment was scheduled to be handed down, his attorneys just dumped their written reply on the registrar's desk and asked the court to hold off on their judgment. They had no valid excuse. The court noted this as a blatant disregard for its rules and flat out refused to postpone the judgment or even accept the late reply. It just goes to show, they might have been lenient on direct access because of the new Constitution, but they absolutely will not tolerate a disrespect for their operational deadlines.
And so, on May 14, 1996, we get the definitive, unanimous ruling from Judge O'Regan and her colleagues. The verdict? Section 24 of B of the Supreme Court Act is not inconsistent with the Constitution. The precondition requiring leave to appeal completely stands, and the applicant's case fails. The system's method for filtering out unmeritorious appeals was upheld as entirely valid, legal, and constitutional.
So, what does this all mean for us? It leaves us with a really provocative question to think about. Are rigorous screening procedures the only way to balance an individual's access to justice with the overall efficiency of our legal system? This case shows us that constitutional rights are not limitless blank checks. Without these filters, our courts would just be completely paralyzed by endless appeals with zero chance of success. But it does force us to ask, where exactly do we draw the line between protecting your right to fight a case and protecting the system's ability to actually function for everyone else? It's a delicate balance for sure. Thanks so much for joining me for this explainer. I really hope it helped unpack the logic behind this pivotal piece of constitutional history.